Welcome to Latte with a Lawyer, a podcast dedicated to bringing you the stories of some of America's most successful lawyers, figuring out what makes them tick, how they creatively solve problems, and how others aspiring to be them can follow in their footsteps.
Okay, folks, welcome to another episode of Latte with a Lawyer. I'm your host, Jonathan Brickman. And this afternoon, we have with us from the state of Kansas, Kyle Sciolaro, and he is with the law firm of BurnettDriskill, and he does plaintiff work on behalf of people with disability claims. Welcome to the show, Kyle.
Thank you. Thank you for having me.
And I probably messed that up with exactly what you do, but you're going to get a chance to tell me. Just to keep with the theme of the show of Latte with a Lawyer, what's your morning beverage of choice?
Black coffee, as bitter as possible.
Bitter?
Yeah, I do like bitter coffee.
All right. Is that Starbucks? I find Starbucks is bitter.
Starbucks can be bitter. I'm good with Starbucks. Buy a lot, honestly, just what's on sale at the grocery store.
There you go. That's what I do too. All right. So good. So tell us about, I know I probably butchered it. So tell us what you really do and what your work is.
Yeah. So like you said, we do plaintiff side work for disability claimants. So the largest area of practice that we've got is Social Security disability. And I think that's what most people think of when they hear disability claim or disability benefits. The Social Security Administration has a lot of resources dedicated to processing disability claims. So those are claims that come from taxes that people pay for through their work, and it covers them in the event that they're unable to work. We also do ERISA disability claims. So many people know, and some people don't know, that they have group disability insurance coverage through their employer that either the employer's paying the premiums on, or maybe the employee, it's coming right out of their paycheck. But those are group plans through insurance companies like Cigna, Hartford, Sun Life, MetLife, those kinds of things. That's our second largest area of practice. And we also do railroad disability claims. And people who work for the federal government, and then just kind of litigation in general for people who are unable to work or have suffered injuries of various kinds.
Okay. And it's all plaintiff work? Is that your practice? Is it all on the plaintiff side?
It is all plaintiff side.
Okay, excellent. So, I mean, there's a difference, right? If somebody's working, and as you suggested, they have some disability insurance from the employer, that's very different than somebody who is not working or maybe never has worked, right?
Yeah, that's right. I mean, there are disability programs out there for people who've never worked, or there's one primarily, which is a supplemental security income. So the Social Security Administration has a program it's a needs-based program. It's a welfare program that medically is the same as the insurance program, that if you're unable to work, you don't have income, assets, or resources, you're basically, if you're in poverty and medically you're unable to work, you can receive benefits in that situation as well.
And so do you handle both types of claimants?
We do. We tend to focus more on the insurance claims, but we do SSI claims for people. I mean, there are plenty of people who are in need. You know, one of the profiles that comes up a lot are women who've worked in the home, for example. So they don't have work credits or haven't paid a lot into the system or have insurance through work, but they still can suffer terrible health problems that would leave them unable to work later on in their life when they may need to, or when they may need income.
Oh, interesting. So even if they have not worked and they suffer some, some disability, you can make the case that they could have gone back to work at some point. Is that what you're saying?
Well, it's more that yes. Yeah, I think that's fair to say in short. So someone, even if they never have worked, they still may be entitled to it because they are currently unable to work. So that can be enough.
Okay. And the amount that somebody can claim, I'm sure is very different, right? If you're just strictly on SSI as opposed to, having a company sponsor disability insurance, I'm sure the amount you're going to be awarded is very different, right? Isn't that the case?
That's exactly right. So the SSI, I think, is bumped up to $810 a month or $800 a month. Okay. So that's a relatively modest amount of money. Whereas with the disability insurance benefit program through Social Security, that's based on a calculation of your highest years of earnings and a portion of that. So that amount is almost always going to be larger than $800 a month, although sometimes not. And sometimes you might qualify for both programs even.
Yeah.
And then the ERISA disability benefit claims. So through group coverage that you've got at work, oftentimes those are 60% or 66.6% of your pre-disability earnings. And you can also draw on that program while you're on Social Security disability. There are offsets, but there are different opportunities out there for people.
Oh, I see. So is that a requirement? What if your company doesn't have that insurance in place, or is that just never the case?
Actually, that's often the case that people don't have that, especially say with very small businesses that just don't offer much in the way of fringe benefits, or they offer benefits, but only if you elect to pay the premiums yourself. So there are many people who don't have any disability insurance benefits at work. We, as a kind of a courtesy to all of our Social Security clients, that's something that we investigate for them. And of course, many times people come to us with denials from the insurance company already in hand, where they knew they had a claim, but they've been denied.
I see. So in the event that they're working, so it's not just pure SSI, and there is no insurance in place, then what are they allowed to claim for? I mean, what pocket can they go into to get to claim?
I'm sorry, and what were the conditions?
In the event that their company doesn't provide any insurance, they didn't have that option, and they're disabled, they have some disability. Where do they go? What's the pocket of money that they can go after for that?
In that situation, if they have been working and paying FICA taxes, they're probably going to have coverage to the Social Security Administration. So
same limitations, only that 881 or some number like that?
No, under that program, if you've been paying in through your FICA taxes, you're paying into the disability insurance program. So in that case, it would be larger than 800. It would be just based on what your earnings were. I think the max now is about $3,200 or $3,300. Most people don't get that as a disability insurance payment, but you can't get that high. For most people, it's between $1,200 and $2,200, something like that.
Okay. So talk about the kind of cases you work on, the issues that you have, and the struggles you go through trying to help your clients.
Well, one of the biggest struggles in the last several years has just been that the Social Security Administration has changed a lot of its rules. So it used to be, and a lot of people still think this, that if you have a supportive physician, a doctor who's willing to say, I think you're disabled and can't work, that was enough. And once upon a time, that would get you pretty far. They've gotten rid of the so-called treating physician rule. So now Social Security relies heavily on physicians behind the scenes who never meet claimants, and also physicians called consultative examiners who do meet claimants, but just see them one time for a one-off evaluation. This is kind of problematic, particularly for, people who don't have much in the way of medical records because they can't afford treatment are going to be disadvantaged by this the most, because their medical records aren't going to say much about their condition. So they're more likely to be sent out for these exams to Social Security. One of the problems that we're seeing, and it really has grown into a big issue here locally, is that some of these vendors that Social Security uses are not reliable at all, and in fact are fabricating reports. But this more general idea of the getting rid of the treating physician rule applies really in a lot of different areas of disability. So even on the ERISA side, on the side of group insurance that you've got at work, it's the same thing, where there's not a treating physician rule any longer. So you've got independent decision makers who don't know much about claimants who are making in a lot of the calls now, where it used to be that treating physicians who knew their patient and knew their situation well and had a long history with them were making decisions. But it's one of the biggest problems.
Yeah. So, so that makes for litigation, I would imagine, right? You have two sides. You have the insurance side that doesn't want to pay, right? And then you have the claimant side that is trying to maximize the award, and you're relying on a physician assessment. So you must use expert witnesses, you must litigate that, right?
Yes, and that's the Social Security rules have actually made that kind of challenging. So in non-Social Security land, getting expert witnesses on the medical side, getting vocational experts, that can be much more helpful. On the Social Security side, the way the rules are written, they are not In fact, they consider their own physicians to be the most qualified. They know the agency rules. They understand the disability program best. So even if you have your client seen by a highly qualified expert, the administrative law judges for Social Security are going to come up with reasons oftentimes why that opinion shouldn't be given a lot of weight. So, and the rules of litigation in Social Security land are quite different than in traditional litigation, and just in administrative law in general, so Social Security, Railroad, ERISA, really to an extent, administrative law is a different animal. It really shrinks a lot of your rights. So you don't actually have a right to a jury trial in a Social Security case. You don't have a right to a jury trial in an ERISA case. You don't have a right to a jury trial in a railroad board case.
Oh, I see.
That's, as you can imagine, that takes a lot of leverage away from plaintiffs and from claimants if you don't have a right to have your peers look at the case, and instead you have a single decision maker who may or may not be impartial, but certainly goes through a high volume of these claims and adjudicates. Sometimes they adjudicate 6 or 8 of these in a single day, and your day in court is a 20 to 45-minute hearing with an administrative law judge, not a multi-day jury trial.
So what is your leverage, and how do you maximize the outcome for your client?
That's a very good question. I mean, we maximize outcome from a client by really scrutinizing the administrative record as best we can. So one example of this, I mentioned the consultative exams that Social Security offers. Something that we've been doing for the last several years is looking in detail at those exams. What we found really starting in 2019 was that one vendor that Social Security uses in particular has language that appears in every single report, even when it's pretty obviously not true. So for years, they were claiming in every single report that the claimant was generally observed to be able to button and unbutton a shirt, pick up a pen and write a sentence, and lift and carry and handle personal belongings. And this struck me as being a little bit unusual because I had several claimants that were older females who were not likely to be wearing a button-up shirt at their exam. Sure enough, I talked to them. They weren't wearing that. Now you think, well, that's not really that big of a deal. Why, how does that hurt somebody? Well, the problem is that claimants who have carpal tunnel or some kind of neuropathy or arthritis in their hands, and they're not able to handle and finger and feel very well, which can affect your ability to work significantly. Unfortunately, the administrative law judges are citing to that very language to say, claimant, you're exaggerating your complaints about your hands. Look, this physician here, who's highly qualified and knows our rules, or so they say, observed you to be able to button and unbutton a shirt. Your hands aren't nearly as bad as you say they are. So we present this argument to the agency with, I would say, very little success initially. Although that particular vendor called Midwest CES, Consultative Exam Services, changed their template up so that no one was buttoning or unbuttoning a shirt anymore, and instead everyone was generally observed to turn and grasp a doorknob. So the same idea here, where they're fabricating language to make it seem like people are capable of doing things that they're not actually doing. Midwest CES happens to have an office down the hall from us. We go down there because it's not very private, can look in there and see there aren't even doorknobs in there. They're levers. You don't turn and grasp. All you have to do is push on it. We complain about that. We end up presenting a large argument with, we've got over 250 of these reports at this point. So we're going after the agency, we're going after the vendor, we're going after the individual physicians. Frankly, it's kind of ridiculous that it's come to this, and that this is what you have to do to get a fair shake at a Social Security claim. You have to file lawsuits against all of those entities to try to get them to correct it. We've gotten at the federal level where we've sued Social Security. We have gotten federal judges to say that these reports are troubling, that the agency needs to look at them. And we've had a little bit of success in getting some of the administrative law judges to realize that the vendors that they're using aren't legitimate. That's an extreme example of the lengths that we have to go through to try to help disability claimants, but it's something that we are spending a lot of our time doing.
So it's not just decided at the state level, you also have federal jurisdiction as well.
That's right. A couple of reasons. I mean, for that is the Social Security Administration is a federal agency, so the Social Security Act governs it, and federal courts have jurisdiction over those. Now, they do delegate a lot of their responsibilities to the states, to disability determination services, so there is some outsourcing and subcontracting at that level. In ERISA claims, the Employment Retirement Income Security Act is also a federal law, so those are typically also heard in federal court. We do have some state court actions, and we file in state court when we can and when it would be helpful to claimants, but a lot of the administrative work that we do is in federal court.
Got it. So is it, I'm just trying to understand, like, what, the cases that you handle, it's not binary, yes, no, there are shades of what the claimant is going to receive.
That's a really good question, because people hear I'm totally and permanently disabled, or they think in terms of a workers' compensation claim where you can get a rating that would be a partial disability rating or something like that.
Yeah.
For Social Security, it really doesn't work like that. Now, there is such a thing as a partially favorable decision, and usually what the reason for that is that the agency has determined that the person's disabled at a different date than what they claimed. So the date that they allege is their disability date, the agency disagrees with and thinks they became disabled later and will issue a partially favorable decision. However, the benefit amount is going to be the same regardless. So you don't, and they will review people at different times. So you'd be subject to being cut off at a different time, but that doesn't mean you're less disabled or you're only partially disabled. And you have a similar situation in ERISA disability claims, except that there is such a thing as partial disability in most long-term and short-term disability ERISA plans. So if you can work a little bit, in theory, you could receive a partial disability benefit. In practice, with both programs, if you're working at all, most of the time, the administrator of the claim is going to use that as evidence to say, well, if you can work 15 hours a week, why can't you work 20? If you can make $900 a month, why can't you make $1,400? So it's precarious.
And how do you get paid? Is it billable hours? Do you work on contingency? How do you get paid?
We work almost totally on contingency. So Social Security fees, those are set by federal law. We have to get approval for any fee that we take, but Social Security will ordinarily withhold 25% of back pay. There are limits on that depending on what level the claim was approved at. But typically 25% on a Social Security disability claim. With ERISA claims, we can have a private contract with the client, and we oftentimes do a third for those.
Oh, I see. But how large can these cases become? It's not like a personal injury lawyer that these can be several $1 million verdicts.
Right. No, there's not, and that's part of the reason there aren't a lot of disability attorneys, really. I mean, compared to some areas of law, it's not that lucrative. No one feels bad for lawyers. I don't mean to say that, but yes, that's right. So the things that can make attorney fees larger are when folks had higher earnings, so their monthly benefit amount would be larger. Also, the more back pay is at stake, the more is subject to attorney's fees. And that does create a bit of a perverse incentive that I think lawyers need to be sensitive to, because there's this perception that lawyers are just going to delay your claim so the back pay can get larger and so they can get more fees. Yeah.
Yeah, no, interesting. So just to is there anything else you want to say about that? Any other thoughts or comments about what you're doing that you think people should understand?
I think that anyone involved in a disability claim, it's really advisable to either study the record that the agency or the insurance company has on your own, which I know can be difficult. And if you're not able to do that, that's understandable. Then you need to get a lawyer, because there are you may be able to get through it yourself and think you don't need a lawyer, and some people are. And hopefully we can get to a point where people don't need lawyers for basic disability claims, but there's a lot of traps and problems and misconceptions and frankly just inaccurate things in records. I mean, the biggest example again that I give is the consultative exams that Social Security is using. This is a huge problem in our area with the one vendor in particular, but it's also a problem in other states. It's gotten some media attention. There's someone at the Washington Post who wants to do a national story on this. Locally here in Kansas City, there have been stories on this. And I don't mean to paint it as a situation where there's just malice by all these physicians, these moonlighting physicians who don't have any training. It's more of a matter of indifference. The volume of disability claims is so large, and you're dealing with the federal government or a large insurance company, that it's just you truly are a number. And the attention that's paid to a claim is many times minimal. They're using templates. They want to get through things quickly and efficiently, I guess is the way that they might think of it,
Yep.
in effect, it's not really very efficient because they're wasting taxpayer money and creating appeals where lawyers like us who are scrutinizing this and appealing them are, there are attorneys on the other end who are having to defend these and be paid to that, and we're wasting a lot of judicial resources. If people would get fair consultative exams and get just a fair shake at it, we wouldn't have to go through all those appeals.
Interesting. And I would imagine that depending on the state that you're in, there's going to be, more or less, right, bias towards the claimant. I mean, you're right.
That's a really good point, because people
Yeah.
think, well, if you're disabled in New York, you're disabled in Missouri or Kansas. Well, crazily enough, that's just not true. I mean, the approval rates vary wildly by state. They
Sure.
vary wildly within the state by what hearing office or what DDS office. When it comes to insurance companies, it varies largely by what vendor the insurance company might be using to review your claim and what physician gets assigned to it. So there's a large, unfortunately, element of randomness, luck to these things. That's a harsh truth, I guess, about it.
Yeah. Well, again, it's your job to sort of to get your client what they should get, right?
Yeah,
But,
definitely.
yeah. So how'd you get into this line of work? I mean, tell me about how you became a lawyer and how you found this niche to work in.
Well, I think I just kind of, in a lot of ways, had the temperament for it at a younger age. I was into debate and chess and kind of nerdy activities, and just live inside of my own head, do a lot of analyzing, I guess, and
Yeah.
went to law school and University of Kansas, and ended up practicing criminal defense actually when I got out. In the county that I was in, there wasn't a public defender's office, so instead they contracted out with attorneys to do criminal defense work. Gosh, I'm sorry, can't seem to get that to turn off.
Oh, that's
And
okay.
so I did criminal defense in Wyandotte County, Kansas for 4 or 5 years. That was exhilarating, very rewarding, meaningful work, I would say, but it's also extremely challenging, emotionally demanding, just really kind of wore me down. So I ended up through a recruiter, ended up with the office that I'm at now. I kind of started out doing a mix of different things, some Social Security disability claims and ERISA claims, and have since kind of focused lately in particular on this issue of Social Security using bad vendors. But the challenge of it to me is the best part. I mean, there's a shortage, I think, of good legal work, unfortunately, in certain areas. So
Yeah.
just got to fight the good fight.
And is that the whole is that the practice of the firm as a whole?
It is. We're a disability law firm. Our
Okay.
largest area of practice is Social Security disability, and our second largest is ERISA disability.
Okay.
We do litigation as well of different kinds on plaintiff side and railroad work, but our brand is a disability law firm.
Okay. And you said there aren't many pure boutique disability law firms, are there?
No, there aren't, and there are fewer. A lot of our, competitors are retiring or just dropping out of the market. I mean, there certainly are disability attorneys, so it's not horrible.
I've talked to the other side that are defending the employers, like federal employers, right? But on the plaintiff side, well, DC, I'm imagining would have some. The DC, right?
Yeah. So yeah, it does depend a lot on where you're at. Here in Kansas City area, I mean, we've got maybe 2 million people total in the metro area, so it's just not a huge city. So, yeah.
And why'd you become a lawyer? I see you went to KU. Well, it's KU, which is interesting. University, I know that because I was in the higher ed business for a while. So it's KU, but it's University of Kansas, the Jayhawks.
Yeah, as opposed to, not Kentucky. Right.
Is that because of Kentucky?
Probably, yeah. But I guess I don't know if I knew or not. I'm afraid I'm going to revise history if I try to say I knew it'd be a lawyer.
That's all right. You won't. I won't know any difference. So you can.
I get, did the political science and philosophy thing, and that's mostly a waste of time unless you're going to pursue a higher degree. And I really like constitutional law and some of the more academic, I guess, areas, which is why criminal defense has a large element of constitutional law to it. So that was kind of what got me hooked, I guess. And then once you get in the legal business and start to enjoy the challenge of it and the reward of helping clients especially at their worst. I mean,
Sure.
it is the times when we're successful is so rewarding. There's a lot
Oh,
of
yeah.
losses too, but that's okay.
You think you'll stay in this practice, this type of law?
Yes.
You will. Wow, conviction. And you're a young guy, so you're
Yeah.
already making that decision right now.
Yeah, we've had I'm the owner of the law firm at this point, so
Oh, this is your law firm.
it is. So I'm all in.
Ah, okay, okay. So you put your stake in the ground. All right.
Yes.
You got
Yeah.
well, but the name needs to change at some point, no?
Nah, that I don't need that. The name's good.
All right, okay. Good. Are BurnettDriskill part of the firm? I assume they're not at this point.
Roger Burnett retired in 2017, and Roger Driscoll's still around. He just he doesn't have to work 60 or 70 hours a week, although he's still here on Saturdays quite a bit. But
Okay.
he still practices.
Okay, very good. Um, anyone else in your family lawyers, or are you the first?
No, I'm the first. Yeah.
Okay. And you grew up in, wait, are you from, so it's Lawrence, isn't that where you, yeah,
KU's in Lawrence.
you're
I'm kind
from?
of the Kansas City area. Grew up when I was real young on the Missouri side, but then ended up moving to the Kansas side. I don't make too big of a deal out of the
Okay.
state
Yeah.
divide. Some people
Is
do.
there a lot of movement between the two sides?
I think
Interesting.
so.
There
Yeah.
is.
It's
Is there
really, I
much
mean,
difference?
I don't think so. I mean, some people cross, you go across and you don't even know that you're crossing the state line. It's
Right.
really, there are some people who get into that heavily, but eh.
What about the taxes? Is there a difference between the two?
Yeah, there are. Missouri taxes actually are, well, Missouri the city has a earnings tax. So that's, although I have never been subject to that living on the Kansas side. I don't know if Kansas or Missouri state income taxes are higher.
Hmm.
I really just haven't ever made much of the difference.
Yeah, yeah. Well, I mean, listen, I grew up in Massachusetts. Maybe you can tell by my accent, but people would go to New Hampshire because there was no state income tax. And in Massachusetts, there's a lot of tax. They call it Taxachusetts.
Kansas got
So
rid
yeah,
At one point, Kansas got rid of the state income tax for small businesses, but I think there was a lot of fuss over that afterward, and they ended up reinstating it. But they
yeah.
tried.
Okay. Very good. What else? Do I need to know about you? So how many lawyers do you have in the firm now?
So there's still, Roger Driscoll, me. There's another attorney, Derek Pierce, who does a lot of litigation and ERISA work. Attorney Andrea Vayner, who does Social Security work. Paul Taylor, who does litigation and ERISA work. And then we have Cheryl Danner, who has a unique role. She's not an attorney technically, but she has a certification that allows her to do hearings with the Social Security Administration and before administrative law judges. So
Okay.
maybe 5 attorneys and
Yeah.
one
Paralegals and
yeah, there's 17 people here total, so we have a lot of teamwork and a lot of help, multiple
Okay.
paralegals, and
All right.
definitely
Well,
essential.
you look pretty relaxed there if running the ship there.
It's a well that then I'm pretending very well.
Okay. And do you use, I mean, what kind of technology does the firm use to become more efficient?
We use Centerbase is our case management software, which most people aren't familiar with, and I wasn't familiar with until we changed over to it. But it doubles as case management and also accounting software. And then we've got the Outlook Microsoft
Yeah.
Office suite. We have some software that allows us to text message with our clients, which has been very, very helpful. We have a lot of we have software that allows us to communicate internally, of course, through text messages. Those are our big ones.
Got it. And yeah, with COVID, I would imagine you guys were not in the office probably, right? Or maybe you were.
In 2020, we did work remotely for quite a while, but we returned maybe by the end of 2020 or early 2021, and now we're primarily back in the office.
Everyone's back in the office. Okay.
Yeah.
So you're not doing the remote or hybrid approach?
Not unless we have to. I mean, we offer
Yeah.
to our clients for sure, and Social Security still does quite a bit of that. So when that's appropriate, we will definitely participate in that. But there's something about looking a client in the eye and just having them meet you, and I think that's worth a lot.
Yeah, I agree. So how many cases a year do you handle? You said
Any
high volume, lots, right?
Yeah, at any given time, we probably have 1,000 matters open.
No kidding. Wow.
Most of them Social Security, which those they can drag on for so long. I mean, especially some of these folks where we're filing lawsuits against Social Security, we have people that we've been representing for over 7 years.
Okay.
So they can drag on. So a high number of matters open at any time.
Yeah, that's a lot. That's a lot of casework.
Yeah.
Interesting. Yeah. And again, most of these things do not go to a jury trial. They're handled.
Right.
Yeah. Okay.
The ones that we have so with these physicians that Social Security is associated with, we do have lawsuits filed against them and against the parent company or Midwest CES, and we have filed those in state court alleging some common law actions, some different state court causes of action, and we think those are better suited in state court. We do some personal injury and related litigation. Of course, those are in state court, and then there are disability claims through group policies that are a lot like ERISA, but are technically not governed by ERISA. So if you work for a government or for a religious entity, or if it's a payroll plan, those are exempt from ERISA, in which case we would file those in state court and ask for a jury trial.
Okay, very good. So, but have you ever done a jury trial yet?
And in my criminal defense days, I did jury trials, but not here. We have not had a jury trial here. We generally, depositions are about as far as we get.
Okay. I would think that everybody who litigates wants that, right? You're waiting for that day. That's the fun thing, right?
And you need to be able to do it at least to show the other side you can, if nothing else.
That's right. I mean, again, talking about leverage, right? I mean, you have to push. Again, most people that do a jury trial, you're pushing, sort of as a threat that, if it doesn't settle correctly, we're going to trial, right?
Exactly.
Yeah. Interesting. All right, good. So just final words that you want to leave with the audience to know about your law firm, about you, and the best way to connect.
Well, don't give up. I mean, that's the biggest thing. A lot of people are inclined to give up on their disability claims. You get enough denials and you think, well, I guess I'm wrong. I need to stop. Maybe sometimes you should give up, but many times you shouldn't give up. So don't give up. Talk to a lawyer. Fight on when it's appropriate. We have the typical social media presence out there with Facebook, LinkedIn, Twitter, Instagram. And we can be reached, of course, through phone call, through text messaging, our business number, fax, and the snail mail. But I appreciate you having me on to talk about some of these issues. And
yeah, absolutely. I mean, you are the first disability attorney on the plaintiff side that I've talked to. So,
all right,
it was good stuff. I learned something every time, so I appreciate it.
Great.
Anyway, for everybody, once again, we have Kyle Sciolaro from, even though it's your firm, BurnettDriskill.
That's right.
In Kansas. And this show is sponsored by Emotion Track with a C, and it's a legal tech platform that litigators use for mediation and trials, and we capture emotional analytics through our AI platform. So thank you, Kyle. It was a lot of fun.
You're welcome. Thank you very much.
You bet.